Hello everyone and welcome to the International Business Law Podcast. I'm your instructor, Glenn Torres-Spelliscy. Thanks for joining me. This week is about introduction, both of ourselves as well as introducing some fundamental principles of international law. It truly is a fascinating time in the international business world, with advents in technology, communications, and transportation. Never before have businesses, particularly small businesses, been so primed to trade with global partners. Indeed, it used to be that the global trading firm required a substantial market presence, vast resources, and government connections before international trade became profitable. That is not true anymore. With a simple click, the smallest of businesses can contract to do businesses with buyers and sellers in a global marketplace. Indeed, according to the U.S. Small Business Administration, 97% of all U.S. exporters are small businesses. Still, that number could be much, much larger, as statistics show that only 1% of all small businesses export at all. Now, as a potential business owner, the opportunities associated with participation in the global marketplace are vast. Companies can engage in direct import-export of goods, widening the pools of suppliers, customers, materials, and knowledge available to help your brand grow. Or you can engage with an international trading company or a representative to export goods on your behalf. There are also ways to establish your brand in foreign jurisdictions, whether by licensing your intellectual property rights or by opening a subsidiary or a joint venture. But the road is also marked by perils. In order to be effective in international business, the business person needs to understand the rules and regulations governing international transactions. To develop these understandings and put you on the path to success will be the purpose of this course this semester. Now let me begin by introducing myself. I am a lawyer by trade. I've been teaching law courses since 2008, and before starting to teach full-time, I practiced law in New York City for a decade, working at one of the largest and most respected law firms in the country, Arnold & Porter LLP. Part of what I tried to do in my classes is to draw on my real-world experiences, to impart to you the relevancy of international legal issues to your everyday life as a business person. In practice, one of the first things that I had to do with a new client was to educate them about the risks and opportunities associated with international business, what rules they had to be aware of, what they could use to their benefit, and how to best protect themselves as they entered into the international marketplace. You'll hear me talk a lot about these experiences through the course. I want to think of this class from the perspective of what it is like to make business decisions. You see, every business decision a person makes has legal implications. Indeed, in my practice, I spend a lot of time in front of various boards of directors, talking about legal risks associated with certain business decisions. That is the approach that I want to take with the course. Let's imagine that we are weighing a business decision and trying to decide what an appropriate business strategy is, given the legal ramifications of our various options. So throughout the course, you will often hear me say that understanding the laws which control and regulate your organization's behavior is a critical component to your organization's financial success and longevity. Why is this? Well, in short, the law's primary purpose is to establish rules needed for society to live and work together. Whether its goal is to protect you from harm, punish wrongdoers, or maintain social order, the law seeks to enforce the accepted rules of the game. It does this through the construction of common understandings and agreements, written or otherwise, about what certain words and actions mean and what the consequences of those words and actions are. And that's critical for business. By creating predictable patterns of behavior, the law facilitates orderly business transactions. Now, as I suggested above, with the growing number of companies engaging in trade law is becoming increasingly important. Over the last 50 years, the value of trade to the world economy has increased by approximately 250%. It's a dramatic increase. And as a result, in order to understand the potential of modern business, the business person must now also understand the potential of international business. So our course begins with the discussion of certain fundamental principles of international law, where it comes from, who it applies to, and how it seeks to resolve business disputes. In addressing the question of where it comes from, we'll study the topics of treaties and something known as customary law, which is where, in the absence of written law, long-standing practices, may acquire legal status under certain limited circumstances. In discussing who it applies to, we'll discuss the concept of states and responsibility, as well as international organizations like the EU and NAFTA and the WTO. And finally, we will discuss the various ways that parties can seek to have their disputes resolved. Business disputes are an unfortunate reality of practice. Indeed, I can guarantee you that as a business person, you will be involved in multiple business disputes, probably on a yearly basis. And this is true at the international level as well. The settlement of international economic disputes can occur through a variety of methods, only one of which is litigation. And indeed, litigation may not always be the most efficient way to settle a dispute from a business perspective. Why? Well, first, litigation is public, and it's noisy. There are ways to minimize how much information leaks from a litigation, but litigations are public records, and so are the proceedings associated with them. In a given dispute as a business, you may not want a public resolution. In fact, in a lot of cases, confidentiality is going to be key. Second, litigation is expensive. And part of the reason it is expensive is also the third reason why it may not be desirable, and that's because it is lengthy. Litigation takes time. There are procedures that must be followed to ensure fairness, and those procedures are intricate and build in time to allow parties to craft the best arguments they can in favor of their respective positions. As a result, businesses must be aware of alternative dispute resolution methods, such as arbitration, mediation, and negotiation. Dispute resolution is, in effect, the art of negotiation. It is the resolution of a dispute either independently by the parties or through the use of an objective, unrelated third party called an arbitrator or a mediator. And there are some dispute resolution tools available at the international level, such as the International Court of Justice, the International Center for the Settlement of Investment Disputes, as well as the dispute resolution body at the WTO. Indeed, from a trade perspective, the dispute settlement body, the DSB, at the WTO offers one of the most important avenues for states to resolve disputes. The reality is, however, that most business disputes, including international disputes, are handled in domestic courts. So we will conclude our discussion with questions relating to jurisdiction, meaning when a court has the authority over both the person and the topic to make a binding decision, as well as potential limitations as to when you can pursue a foreign government as a defendant in domestic courts. This is probably an area of the law that you have not given a lot of thought to, and we have a lot of work ahead of us. There's a lot of ground to cover. The study of international law can be tricky because it's not evident in our daily lives. We all interact with domestic laws on a regular basis, and there are many times where it is obvious, but the same is not true about international law. And that is because the interactions with international law occur at a deeper level. But make no mistake, international law affects the types of goods available to us and the costs of those goods. As we study this body of law, we have to remember that international law is still young, so there are areas that are not developed or are underdeveloped. Most of the modern trade regime was constructed within the last 75 years in the aftermath of World War II. So there are going to be areas where the answer to a particular question seems unsatisfying. But that also provides us with an opportunity. You see, we're going to be one of the first generations to be able to shape what the law will say about the various important economic issues we face. And I hope you enjoy the course. Let me know if you have any questions, and I will see you on the discussion board.